So, as for this proof of fixed place of abode owner, which is which the applicant has to prove to this court, I don't know what we are going to do in these circumstances. Another condition which has to be satisfied in this court are the sureties of the accused person, of the applicant. The sureties who have a duty to produce this person in court, to explain to court whether this person is okay. If she has refused, they drag her here so that she can attend her trial as per the objectives of a person applying for bail. As much as the applicant tried to identify her sureties, Your Honor, I wanted to know if these people are truly her friends. Does she even know where they stay? In that one of them can stay with her, but she appeared to be very disrespectful, saying they stay in their homes. Now I'm stranded, I don't know what to do. Probably I would have agreed that maybe she stays with one of the sureties. But her response was so rude and unbecoming. So, Your Honor, I don't know whether even the applicant knows where the sureties stay. It was very important for me and to be satisfied, to the satisfaction of court, that the applicant knows her sureties and where they stay, and deeply knows her sureties. And lastly, some of these sureties have not been truthful. I don't know whether they were not truthful to their lawyers, or that the information they actually gave the lawyers was untruthful. I'll go to Honorable Lucy Akero. Yes. You know, when we are looking at applications of bail, we want to trust the sureties because we entrust them with a mandate to produce the applicant in a court. But when a surety gives false information, then we don't know what to do. The surety gave us a number that she uses, which is 0702576006. Yona courteously I asked for 1 hour to verify whether this number is registered in the names of the surety. And what I found out is that this number is registered in a person called Sarah Namuswa. Yet the surety here is called Lucy Akero. Yet the accused is saying, this is my friend. Now, if I'm looking for the accused and I want to trace the surety, I have a phone number in the names of Sarah Naruswa. What am I going to do? This creates fear that the applicant's surety is not being truthful. And it creates fear that this person may cover up even for the actions of the accused, whether she's going to go or she's going to come back. You know, we don't know. And such reasonable doubt is so unsettling. Another issue about Madame Lucy Akero. She has duties as an MP in Amuru district. My problem is, the accused is a resident of Luzira. That is if she's going to stay in Luzira here. How is she going to command this lady to come back to court when she's busy in her duties in Amuru district there? First she gives us a wrong number. She's outside this jurisdiction. It is so disturbing, Your Honor. And then I also have a problem with this. He's called, he was not identified by the applicant, the false surety. This surety, yes, let me go by his letter. I hope the letter is okay. Let me use his national ID. He's called Godba Wilson Tumusime. They said he's a lawyer. Tumushabe? Yes. They said he's a lecturer, a lawyer. But this surety also is not truthful, Your Honor. This surety gave us a number of 07750000737. This number is also in the names of a woman. Yet he's a man here. That is why I wanted to see him. He's a man actually. But this the name is Ashemeri Agnes. You know? So how are we going to find the applicant through the sureties when the sureties are giving us wrong information? When I go to the medical report, yes, Your Honor, police form 24. The applicant has told the court that for her she's unwell. But unfortunately for her, she has not produced any old medical reports to substantiate what she was saying. I offered my police form 24 yesterday to her. And I even asked her, Madam, were you medically examined? She vehemently said, I have never been examined. In her own words, Your Honor, I'm not even putting words in her mouth. I have never been medically examined. Yet, according to me, a police form 24 is a document filled by a police sergeant who is a doctor, who has fully examined the applicant. But she stood here in her own words and claimed for her that doctor just wrote her own things. For her, she has never been examined. Now, I find it peculiar for my land friends to hold this document in high esteem and say for us, we are relying on this document, our client is unwell. Yet the client said, me, I've never been examined. Now, Your Honor, I'm in a dilemma. I don't know. Most of the times when an accused person stands up and objects to this document, the court gives an order for an independent examination. So, I don't know if my land friends have other documents to rely on, because your client vehemently denied the document in court. So, Yona, I feel that point of being unwell and terribly sick, I don't know how they are going to prove it. In conclusion, I have studied the character of the applicant, Yona, from the time she came to court up to now, Yona, when I examined her in a friendly way, and her response. We fear that she may continue using words which may amount to committing offenses. And Yona, this is among the conditions. This is among the conditions which court has to look at carefully under the bail guidelines. The likeliness of the applicant to commit an offense while on bail. Their character has to be put in play, the way they present themselves. Are they being courteous? Are they being adamant? Yona, me, that was my observation in court here. However, if this court is inclined to grant bail to the applicant, we humbly pray that the applicant surrenders his passport to court as one way of ensuring that she will not run away from us, because she said she's already on the run. So maybe the passport, if it is handed over to court, she may not run away. And we also pray for an order refraining the accused, or stroke the applicant, from using such words the state may consider committing a crime. At least she should refrain. I'm not saying she should not talk, but in my prayer is for her to be refrained from committing further crimes. What statements that may be taken by the state to amount to committing a crime which is as similar as this crime we have here. Thirdly, Yona, we pray for other reasonable terms, Yona, that you may consider fit. That will also ensure that the applicant comes back to court for her trial. So I pray, Yona.
Your Honor, in a brief rejoinder, Asime Anthony, Your Honor. The state started from submitting on the objects of bail as alluded to in the guidelines. But Your Honor, if I may ask if the sureties can be allowed to sit.
Yeah.
Thank you. But she skipped some very important guidelines. In that paragraph, number G being to reduce incidents of pretrial detention as one of the reasons, and H to safeguard the interests and concerns of society in bail decision making. Similarly, Your Honor, she alluded to paragraph 13. And also under that paragraph, skipped also important considerations. A being the gravity of the offense. E being the applicant's age, physical and mental condition. Your Honor, on the aspect of the national ID and passport, we actually have those documents in court. Yes, Your Honor. But what I wish to state is that depositing a passport may be a condition set by court. It's not a sine qua non. It's as and only when the court deems fit. But we do have the same. In fact, we have the copies of the national ID and original ID as well. Probably if there was a mix-up, but I can avail court copies of the same and the passport as well. Your Honor, the state alluded to the authority that was provided in respect of advanced age. But Your Honor, yes, Your Honor. I think, Your Honor, the land state attorney misinterpreted the provision or the decision of court. And I'll again refer court to the decision we availed, Foundation for Human Rights Initiative versus Attorney General, where the court was simply saying that those exceptional circumstances are not mandatory. I think the prosecutor is mistaking the conditions for bail with eligibility for bail. Mistaking the conditions for bail with eligibility. What we are saying is that Dr. Miria is eligible for bail in the circumstances. In respect of PF 24, unless the state prosecutor is trying to tell us that the documents availed to us on their own, on the court file, are wrong documents or procured in a wrong manner, but he took this as the evidence availed by the state, because they are the ones holding the applicant at a time. But most importantly, Your Honor, I want to retaliate the earlier submission on being granted bail on her own recognizance, and I will cite paragraph 18 of the bail guidelines. 18 of the bail guidelines, which provide that the court may grant bail to a vulnerable person on his or her own recognizance, or on the recognizance being entered into by his or her parent, guardian, or other responsible persons. But on her own recognizance, Your Honor, which was the first limb of our submission. And it is on that basis, Your Honor, that we retaliate our prayer. Your Honor, I'll allude to the holding in another authority we submitted, Uganda versus Kano Dr. Kiza this year. That's constitutional reference number 20 of 2005. Where a court held that the applicant should not be deprived of his or her freedom unreasonably, and bail should not be refused merely as a punishment. Applicant should not be deprived of his or her freedom unreasonably, and bail should not be refused merely as a punishment, as this would conflict with the presumption of innocence. That the refusal to grant bail should not be based on mere allegations,